Good morning, everyone. Looks like there's some folks still jumping on the line, but we'll get off to a start here promptly. This is a much anticipated webinar. We appreciate you taking time to join us to discuss developments at the United States Department of the Interior, especially over the last few months. This is part of our Environmental Essentials webinar series. It's designed once a month, typically, to bring to you some key facts, some key insights on developments that seem very important to our client base. Frankly, to make it a little easier for you to stay on top of the many responsibilities that you have. Today, I'm going to have the pleasure of interviewing my colleague, Ann Navaro. I'm Kevin Ewing. I'm resident in Graceville's Washington office, and Ann is also resident in Washington, D.C., although neither of us is at the Washington office itself today. Ann has had a long career in natural resources law. Many of you know her. She spent more than 10 years, I guess, at the Justice Department in the Environment Natural Resources Division. She also spent about 10 years litigating and ultimately leading and managing all the civil works litigation at the Army Corps of Engineers. And at the Department of the Interior, she had very senior legal and policy positions as counselor to the Secretary. So she has a terrific perspective from which to give us a sense of what we're seeing and where it's heading in the Interior Department this morning. So Ann, welcome.
Thanks, Kevin, and good morning, everybody. I'm glad you could join us.
So let's start off with some basic perspective. Are the changes that we're seeing right now at the Interior Department substantially more aggressive or far-reaching or surprising than is customary when there is a change in political parties in the administration from one administration to another, or is this par for the course?
Well, I would say yes. That's my perception. I mean, of course, it's part of a trend. There's always been a reset between administrations of different parties, but since I started in government in 1992, I think the swing has been getting more dramatic and kind of more immediate in terms of the change in administrations. There was, of course, a big swing at the beginning of the Trump administration as they sought to quickly undo many of the Obama administration's initiatives. But I think this one is yet a step further.
Well, that's interesting. I have a sense that a lot of the change is focused in areas that matter a lot to oil and gas. So why don't we turn there first? What's happening in the oil and gas leasing pause? What's that all about and where's it going?
Sure. Well, as you know, and as I'm sure a lot of our audience knows, this is a pretty significant initiative for the administration in terms of implementing one of President Biden's campaign promises. Interior is implementing an onshore and offshore oil and gas leasing pause as directed by one of the January 27 executive orders. And they're going to be undertaking a comprehensive review of the oil and gas leasing program on onshore federal lands and in offshore waters, similar to the review that the Obama administration Interior Department did of the coal leasing program, although that one didn't really play out totally given the change in administration. So the specific parameters of the review have not really been publicly defined, but I think we can assume some key elements based on what's been said and what's been written by folks who are now in the administration. First, I just want to remind folks about the process. The Department of the Interior held a listening type stakeholder forum at the end of March, in which Secretary Haaland participated. People can still submit information about the oil and gas leasing program until the end of next week, even though as of yet there's nothing really to comment on. And then Interior says it's going to have its interim report out in early summer. And I would expect that to be the predicate for the more comprehensive review that could even involve revisions to resource management plans and things like that that will play out over a much longer time period. I would also like to note that as part of this review of the program, Headquarters Interior has kept review authority at a headquarters level over certain types of decisions that are typically approved in the field. And that includes renewals of applications for permits to drill, lease suspensions, and certain types of NEPA analysis. And I think that initiative, it's indicative of the focus on the notion that there is an over inventory of APDs and oil and gas leases, and that they really need to scrutinize NEPA reviews to be sure that the agencies, BOEM and BLM, are properly focused on climate and environmental justice and tribal concerns. Secretary Haaland has called the leasing program broken, and that is certainly indicative of the going-in approach. I'd also like to mention litigation that's been filed. There was an early lawsuit against the president over the January 27 executive order. I kind of doubt that's going anywhere. But a bunch of states have now filed suit in federal district court in Louisiana challenging the moratorium and challenging the specific suspension of certain lease sales, in particular, a couple of offshore lease sales. And that's a pretty substantial lawsuit. In fact, the plaintiffs have just filed a motion for preliminary injunction in that case to try to compel Interior to disregard the moratorium and reinstate certain lease sales. The government has about 21 days to respond, so it will be interesting to see how that plays out.
There's a lot there to unpack. Let me follow up with a couple of questions. One, as you pointed out, the lease pause appears to be focused on making sure that climate, environmental justice, and tribal issues are more appropriately taken into consideration. And yet I think the policy grounding in each of those areas is in change, is dynamic and is uncertain right now. So it's not like there's a reset to something that's certain. It's a reset toward objectives that are themselves not yet set. Is that a fair statement, or do you see it as more certain than that?
No, I think that's a fair statement. I think what this administration intends to pursue goes far beyond any efforts that the Obama administration attempted in this area. So there isn't really any reset that I think this administration would view as achieving their policy goals. So I think this is a whole new thing. Of course, the president promised no new leasing on federal non-tribal lands. So I think that's a possible outcome of this comprehensive review. Of course, that'll be heavily litigated under both the Mineral Leasing Act for onshore lands and the Outer Continental Shelf Lands Act for offshore lands. I mean, I do think that, you know, we can kind of predict some elements as to how this is going to play out, given the framework that that the review is based on. For example, we know that the new administration believes that oil and gas development doesn't sufficiently account for the social cost of carbon. We know that the new administration views the fees and royalties associated with oil and gas leasing and production as being outdated, stuck in the 50s, and that 1950s, and that they don't provide a proper return to the public. We know the new administration believes there's a surplus inventory of leases and permits to drill out there that it views as tying up public lands and preventing other uses. We know the new administration believes that climate and environmental justice and tribal concerns have often not been sufficiently taken into account. So along those lines, I expect to see some proposals for some type of royalty adder, for example, to account for the social cost of carbon. I expect to see perhaps a change in the approach to NEPA reviews for APDs to better take into account the social cost of carbon, climate, tribal, environmental justice issues. I expect to see the agency considering whether additional mitigation to account for the social cost of carbon can be required at the APD stage, whether they can increase rentals and bonus bids in leasing. I think there are some folks who have thought hard about these issues, who think that permitting and leasing should reflect a net zero approach, and that mitigation requirements could be added to APDs even without a rulemaking. So I don't know if that's going to be tried, but I think there are a lot of very aggressive ideas out there that are being considered. Interior has said that it doesn't intend to interfere with validly issued leases or existing operations. But I still wonder how a change in approach to APDs or even considering taking away some royalty deductions and adding more mitigation might affect leases that have already been issued that aren't the subject to court challenge. So I think we're really looking at an approach that has the potential to have serious impacts on the whole industry chain that is reliant on production from federal leases.
It does seem extremely far-reaching. I recall just a few years ago under OFFSHORE in the offshore wind, so renewable energy program, they started doing lease auctions where the non-price factors were very significant. That is to say, the bids were on a financial basis, but after you had already proposed a non-price commitments that you would adhere to as a bidder in the auction if you were successful. And in this way, the auction ended up driving lots of non-financial commitments by those who wanted to participate and compete in the auction for new leases. That has persisted over the last few years. I think we'll see more of that, and maybe it'll bleed over into the oil and gas area as well. Different statutes, but nevertheless an interesting idea. Let's turn for a second to the renewable side of the equation. How do you see the renewable sector being affected by some of these and similar changes, particularly onshore, and then later we'll turn to offshore?
First, I forgot to ask to go to the next slide. So if we could go to the next slide, and then folks will just have that in front of them, even though I've been over, I think, that information. Well, in terms of renewables, again, that's an obvious emphasis for the new administration. I think starting day one, the Department of the Interior was really engaged with the bureaus, so the Bureau of Land Management and the Bureau of Ocean Energy Management in particular, to start to look at opportunities to identify areas that are suitable for renewable development and to figure out ways to expedite processing of those reviews. Of course, big renewable projects, onshore and offshore wind, solar, raise many land and water use issues and species issues that also drive objections and litigation over those projects. So while the administration is very enthusiastic about those projects, I expect to see the same, in essence, very similar types of concerns, less the climate concern, about those big projects from some stakeholders as we see to oil and gas projects.
It does seem to me that the administration has not yet figured out how to strike a balance that works between their very aggressive renewables objectives on the one hand and their insistence on more extensive environmental, climate-related, environmental justice-related, and tribal-related analysis. The two move in different directions. One takes a lot more time and intensive effort and develops a lot more uncertainty. And on the other hand, you have this desire to accelerate renewables. Do you see that as a dichotomy that has to get resolved, or is it just going to bump along as an unacknowledged imbalance in their approach over the next few years?
Well, I mean, I personally think that because of their very strong commitment to renewables, that is going to, in some respects, override other concerns. I do think that the Department of the Interior, in reviewing these projects, will be focused on species issues, land use issues, tribal concerns, environmental justice concerns. But I do think that their commitment to large renewable projects will be the most significant factor in review.
Kind of an override. Well, there's a lot of subjectivity in these analyses, both under NEPA and under the Historic Preservation Act and in other reviews. So that's certainly possible. Renewable development, and you mentioned habitat and species, both oil and gas and renewable projects on federal lands often have an intersection point with migratory birds. Let's turn to that. The Migratory Bird Treaty Act is again in discussion. It seems to be the perennial in Washington. You've been through various iterations of it yourself over the years. And we've had some 180-degree flip-flops, basically, of policy under the MBTA. Well, what's the status now, and where do you anticipate that going?
Well, and this is one of my favorite topics, Kevin, because, it's just amazing to me that a 100-year-old statute can still engender so much controversy and uncertainty in terms of how it's implemented. I think, as most folks on the phone probably know, for decades, the government enforced the statute based on the notion that it criminalized both the direct take of birds covered under the Act, which is essentially all birds, as well as incidental take of birds under the Act, so that, projects like wind projects that don't intentionally harm or take birds, but they kill birds, are also subject to enforcement under the Act. So that was kind of decades, starting in maybe the late 1970s, mid 1970s. The Trump administration changed that interpretation and concluded that the statute only criminalizes the direct and purposeful take of birds. And that was in line with a not too old Fifth Circuit decision that concluded the same thing. The Biden administration and the Trump administration interpretation was very controversial and objected to strongly in many quarters. Not unexpectedly, the Biden administration immediately revoked the Trump administration's legal opinion to that effect. It dropped the government's appeal of an adverse decision that was a challenge to the Trump administration opinion, and it has stated its intention to replace the Trump administration rule and go back to the previous interpretation where it is enforcing over incidental take of migratory birds. As we sit here today, there is a rulemaking under review at the Office of Management and Budget that will replace the Trump administration rule and codify the incidental take definition. I doubt, and that draft rule is not yet public, I doubt that draft rule yet sets up any sort of permitting opportunity or program, and that would be a next step. And that was really, that became a big problem over the years, because the government interpreted the statute as criminalizing incidental take, but didn't provide any meaningful way to get a permit or seek review. It was all kind of informal, and enforcement was up to the discretion of the government. So it left industry who, wanted to comply in a pretty awkward situation. So I imagine that this administration will make more serious efforts to try to come up with a permitting program. But in any event, once their new rule is issued, I do expect that they will interpret it as applying nationwide, even in the Fifth Circuit, which was the circuit that held the statute only applied to direct and purposeful take. So I imagine there will be much more litigation to come under the MBTA, and it will certainly be interesting to watch and complex for industry as it tries to deal with the changing environment.
Well, that certainly doesn't sound like it's all going to be neat and tidy within a single 4-year term here with the Biden administration and potentially longer terms. Let me pick up a thread of something you touched on earlier, which is tribal considerations and perspectives. Secretary Haaland's tribal heritage is widely recognized as an important part of her perspective on all issues, and she's been frank about that herself in her testimony and otherwise. And we've heard the Secretary, and I think more generally the Biden administration, emphasize the desire for deeper engagement with tribal nations. You've mentioned that yourself. How do you see that actually unfolding in practice?
Sure, and I'll just be brief because I want to hand it off to you to talk about offshore wind. But I do think this is absolutely key. I think Interior will be looking for increased tribal involvement, both in management of tribal lands, which was a serious effort in the Obama administration as well, but also in management of non-tribal public lands. And I think that is going to be developed much further in this administration. It may mean more robust consultation with tribes who have historic and cultural attachment to a particular area. It probably will mean more deference to tribes' place-based knowledge and their understanding of the lands at issue. I also think the new administration is going to be looking for more opportunities for direct tribal involvement in management of all sorts of lands managed by the Department of the Interior. Secretary Jewell, the last Interior Secretary under Obama, issued an order that attempted to get there, to give tribes a real role and say in management of, everything from national park type properties to refuges to BLM lands. And direct involvement is a little bit constrained by the relevant laws, but I expect that this administration will attempt to broaden that and certainly will bring the tribes into a very robust informal consultation role.
I think you've hit on what I also consider a central point, at least from my perspective. I think developers of infrastructure have been looking at tribal engagement as, of course, necessary and appropriate, but largely contained within and managed through the National Historic Preservation Act, Section 106 consultation format. But what you're talking about here is a sovereign to sovereign discussion outside the framework of a project specific, Section 106 review. This is a sovereign to sovereign engagement about how a leasing program should be designed and administered. And that's a much deeper and more profound kind of engagement, very different from what we've seen previously.
I think that's right.
Yeah, that'll be very interesting, and it'll play through lots of different issues. Let me, in a couple of minutes, just quickly orient people to what's happening on the offshore renewable side of things, in particular offshore wind. We don't yet have offshore solar, but maybe that'll be a webinar in the future. There's been a lot of activity there, and it's interesting to juxtapose because the nature of the activity is so different from what's been happening on the oil and gas side, which has been pause, review, reconsider, reevaluate, et cetera. Offshore wind development on the Outer Continental Shelf, which is federally administered, has been, accelerate, speed up, don't pause, don't reconsider, move forward. They took very quick action after the inauguration on Vineyard Wind's EIS. You may recall that just before the inauguration in December, Vineyard Wind, which is a large commercial scale offshore wind development, actually withdrew in its entirety its application for a permit after multiple years of NEPA and other work, and then resubmitted it right after the inauguration. And one question was, well, do you have to re-kickstart all the NEPA Biden administration said, nope, we're ready to pick up where we left off, and moved that through very quickly. By March 8th, there was an EIS out there. We also had a significant and intended to be significant, White House confab, I guess last week it was now, that brought industry and some coastal states and the labor movement, which is an interesting threesome, together. It was led by Secretary Haaland, had lots of statements from all the, poobahs around offshore wind. And the idea there was to highlight that there was going to be an acceleration toward 30 gigawatts of offshore leasing in hand by 2030. They saw that as tied very specifically into responding to the pandemic, the economic downturn, racial injustice, and climate crisis. Those four things were viewed as supporting and explaining this accelerated move. Next slide, please, on offshore wind. The other interesting and very significant development was that they announced a new wind energy area designated the New York Bight. And for those of you who know the East Coast, you know that, there's sort of New York and Long Island here, and then there's kind of a crook to the elbow, and there's New Jersey, and this is the New York Bight, B-I-G-H-T. It's been trafficked for commercial fisheries and other uses for centuries. They are interested in considering auctioning leases within an area that's 800,000 acres in a place of very, very proximate to demand centers like New York, and even reaching up to Boston, of course, New Jersey as well. That's quite significant. I'm going to show some maps in a moment to give you a sense of scale and pace. They also issued the notice of intent to prepare an EIS for the for ocean wind, which is offshore New Jersey, and that's just accelerating from Vineyard to South Fork. There's a commercial scale, and then ocean wind, and probably next up will be the Empire Wind Project. So in quick succession, possibly four that will be ripening here in the next few months. Next slide, please. The New York Bight call areas are all those blue areas, and you'll see in the center one, the one that looks like a triangle, there's kind of a grayed out little point pointing right at Manhattan. That's already been leased. That was a huge lease area. It went to Equinor. Next slide. Thanks. That piece of it is sufficient to support at least two very large scale, probably 1.2 in total, 1.2 or more gigawatt worth of power projects and offshore wind. Next slide. What the New York Bight announcement said was, in those areas, all those green areas are going to be potentially up for auction, starting possibly as early as the end of this year. You can see the scale of it. That red circle was sufficient to support, a couple of gigs worth of new energy. So each of these areas is quite large, and the one offshore New Jersey to the south is enormous. We are going to see multiple lease auctions, I think, that repeatedly try to put these lease areas into competition. Next slide, please. Looking ahead, the constraints are numerous. Offshore wind is still very expensive. It's expensive to develop. It's also expensive to integrate into the grid. BOEM staffing is really insufficient. They're working their tails off, but they just do not have the staffing on the offshore wind side to manage this. And so what we're going to see is a lot of personnel movement, I think, from the oil and gas program to the offshore wind program, and potentially hiring from outside as well. There are big policy gaps, things that just haven't been decided yet, that need to get decided in order to maintain this surge on offshore wind. We're also missing the port development that is necessary. When you go to the Gulf Coast on oil and gas, you have a lot of infrastructure onshore that supports the offshore oil and gas regime. We don't yet have that onshore to support the offshore wind industry. That needs to come along. And of course, the Jones Act is a limitation as well that needs to be figured out. And finally, we have a lot of commercial fishing that's been happening in the Bight for a long time up and down the Atlantic coast. So we have some challenges there, and it'll be interesting to see how the administration chooses to tackle them while putting its foot on the accelerator. That's a quick once through on the offshore wind side. And I think we're right about at our half-hour limit. One of the things we try to do is keep it to a half hour so that you can get back to your desks. We hope that this has been a useful, quick bite insight on what's happening at Interior. Ann, thank you very much for sharing your thoughts on where things are heading. All of those who are participating, feel free to reach out to Ann or me. We're always glad to talk with you. As a reminder, in May, Bracewell will be hosting again the annual Spring Environmental Seminar. We'll hold this one virtually again. That seemed to work well. We're going to split it over a few days, so it's never taking a big chunk out of one day. Stay tuned. The agenda is looking very strong for that, and we're excited about it. We'll be shipping something out to you by email probably in the next couple of weeks. Thank you all. Meanwhile,
Thank you.
stay safe and be healthy.
Thank you, everybody. Bye.
Bye-bye.